Hello, I'm John Buckert. I'm going to discuss why you should hire a patent attorney to protect your product. First off, the process for obtaining a patent is rather complex and long. It typically takes 1 to 3 years, even if all the upfront legal work has been prepared and filed properly. So if you try to file independently and not hire a patent attorney, you can waste a substantial amount of time and money in trying to negotiate a rather complex process that you may not be familiar with. Also, you may end up with possibly no patent protection for your product. Now, patent attorneys are licensed experts who specialize in obtaining patents to protect new products with the Patent and Trademark Office. And a patent attorney can assist you in several areas. First off, the patent attorney can perform a patent search to determine the closest patents and provide a solid opinion on whether your product is patentable based on these patents. Now, this is important because you want to know up front the probability of patenting your product so you don't waste your time and money, which no one wants to do. After performing the patent search, the patent attorney can give you a reasonable opinion on whether your product is patentable. Secondly, the patent attorney can select the correct type of patent application to use for your product. There are two primary types of patent applications. The first is a utility patent application, and the second is a design patent application. A utility patent protects the functional structure of the product, and a design patent protects the external look of a product. The patent attorney can provide guidance on the best type of patent application to use for your particular product. In some instances, for some products, the party may have a much higher probability of obtaining patent protection utilizing a design patent application, for example. Thirdly, the patent attorney can properly prepare and file all the necessary documents for your patent application. Now, along with the application, there are several documents that must be prepared and filed correctly, including an application data sheet, a declaration, and a power of attorney. And if these documents aren't filed correctly, unfortunately, the USPTO can reject the patent application. Fourthly, the patent attorney can handle the negotiation process with the Patent and Trademark Office so that you have a much higher probability of obtaining patent protection. In the negotiation phase, which is also called the prosecution phase, the patent examiner examines the patent application and performs a patent search to identify the closest patents. Afterward, the patent examiner often issues an office action rejecting the application. This is very typical in the process and happens in over 90% of the cases. Now, afterward, a response document must be filed and prepared, obviously, to address the examiner's concerns in the office action. By having a patent attorney prepare the response document, which complies with all the USPTO requirements, you greatly increase the likelihood of obtaining the patent on your product. Fifthly, the patent attorney can obtain claim coverage that is broad enough to cover your product and to stop competitors from copying your product. The claims define the scope of protection and need to be carefully drafted to obtain the protection you need. A well-trained patent attorney can draft claims that will give you the desired protection of your product. In summary, by having a patent attorney handle the patent process from start to finish, you'll have a much higher probability of obtaining patent protection. Also, you'll free up your time to focus on what you do best. That's developing and marketing new products and growing your business. If you have a new product that you're interested in protecting, please contact us at 248-853-1422.